And I've got four topics really to talk you through today in this half-hour talk. The first is the historic position, and we can look back over previous legislation and previous case law. I'll then move on to examining the UK test versus the EU test and looking at the current differences between the two. We can then look at some more recent case law and the impact that it has had on those two tests. And finally, we'll finish with a bit of future looking, thinking about how these legal positions may change post-Brexit in light of some new legislation. So looking ahead, well, the thing we've had most recently was Ruler. This came into force last month on the 1st of January, and this wholly removed the principle of supremacy in respect of EU law. It was meant to be, before Ruler, we were talking about the bonfire of EU laws. There wasn't a major bonfire of EU laws, but some did go, some IP laws, I think only 7 and not major ones. The rest of the law, previously called retained EU law, was rebranded as assimilated EU law. But the whole idea of Ruler is it enables divergence and it encourages a detachment from EU legislation. So, for example, sticking to things like the InfoSoc directive, it seems to be a thing of the past. And you would have thought that, therefore, this would be an area ripe for divergence. Under COFML, the only criteria for copyright protection, as I have said, is originality. But the English courts so far seem to be looking for works to display artistic or aesthetic appeal. But even on that test, per Response Clothing and perhaps Waterower, that's still a large body of works. We know from Response Clothing that Hencher was too inconsistent. We know from Lucasfilm that works that were created with primary aim of giving an impression to a particular film, supposed to opinion aesthetic, was the main thing that drove the judge's decision, and that the Supreme Court didn't have a chance to look at it. And we know that the test in Bonds has already been approved twice, including in Lucasfilm, and now relied on Response Clothing. But the big one to look out for is the decision on Waterower and Viking. This hearing took place last summer, and the judgment was expected to be handed down in October of last year. It still hasn't been handed down at the day of recording, and this is likely to be the most informative decision on this subject matter.